Hi everyone, welcome to Pragati Vichar Literature Festival 2023 organized by Frontless Media, and this year's theme is Taking Humanity Forward. So today we all are present here to celebrate the love for literature and discuss the pivotal subject matters which are prevailing in our society and establish engaging conversation with professionals, your favorite authors, as well as with the audience. So today we have very professional people. I would say lawyers, not authors. Today we have on panel. First is Ishani Chandra, and second we have Surbhi Iyer. And we're immensely glad to have both of you for the PVLF 2023. And I'm hoping that your perspective will gonna add value to our literature festival. So thank you so much for joining us today.
Thank you, Jyotsna.
Thank you,
It's
Jyotsna.
a pleasure to be here.
It's our pleasure.
So first on panel we have Ishani Chandra. Ishani Chandra is managing partner at Sagar Chandra and Associates, and she heads the trademark and patent practice of the firm. She started her practice in one of the India's leading IP law firm in 2012 and in 2010 joined Sagar Chandra and Associates as a partner. She has extensive experience in intellectual property litigation and prosecution. Her work encompasses brand development, prosecution, and protection of trademarks both in India as well internationally, copyright prosecution, and informants and patent litigation. So thank you, Shani Chandra ma'am, and I hope that I was justice with your introduction.
Absolutely.
Whole list that Lavanya shared with me.
Just, I just wanted to add that I'm also the president of the Delhi Arts Leadership Council of the Women's Indian Chamber of Commerce and Industry. And through that, I have been working extensively with all kinds of artists, including authors, poets, painters. And that also adds a unique perspective to what I'm going to talk about today.
Okay, thank you so much. And last but not the least, on panel we have Surbhi Iyer. Surbhi Iyer is a partner at Sagar Chandra and Associates as well, and she manages the IPR prosecution and transaction teams of the firm. Surbhi has joined Sagar Chandra and Associates in 2012 after her graduation. She has extensive experience in intellectual property prosecution, IP adversary, and related transactional assignments. Her work encompasses managing trademark portfolios across sectors, and she advises clients ranging from MNCs to startups on branding, coining, brand development, prosecution, and protection of IP both in India as well as internationally. And also she also takes care of media and entertainment of the firm. Am I right?
Yes, that's right.
So welcome. So today's session theme is copyright, and I feel like copyright is very necessary since we are facing, so many piracy problems and copyright infringement, and it is a totally most talked about topic right way across the publishing industry or in the society as well. So under this theme, we have topic an author's guide to copyright. So since it's a literature festival, we are more focused on authors. So we will talk about authors copyright today. So my first question, which is journal to everyone, it's like very common. What is the difference between a trademark, a patent, and copyright? So I would like to start with Ishani ma'am.
Sure. So, there is a lot of misinformation or, confusion among the general public about the various types of intellectual property. Now, all three of these, whether it is trademark or it's copyright or it's patent, are forms of intellectual property. They are property rights that are given about, for things which are created from our mind, to put it in the simplest words. A trademark is basically a brand. It's a name that you give to your venture, or even in the case of authors, the title of your book could be treated as a trademark because it has a entity in all itself. The book sells because of the name sometimes. So the name of the book in the case of an author would be a trademark. In the case of any other company, the name of the company or the name of the brand would be a trademark. Whereas copyright is the right that is given to creative people to protect their outputs. So there are many kinds of copyright here in most particular for the author community. There is a copyright in literary works. There is a copyright in artistic works, which is applicable to, say, painters. There is copyright in sound recordings, which is for and musical works, which is for people who write music. And there are copyrights in cinematograph films, which are for filmmakers. So copyright is actually a bundle of rights which is given to creative people to protect their work. And patents is the rights which are given to the scientific community for coming up with new inventions. So patent deals with science, it's about new inventions. Trademarks is names which have come to have a meaning associated with companies and brands. And simply put, copyrights are the rights which are given to creative people to protect their work or their output. Surbhi, would you like to now take it?
Yes, of course. So that's, Ishani ma'am has very well captured what is the essence of, three different categories of work which were talked about. So like she said, trademark, the purpose of a trademark basically is identification of source. So, that happens with us so commonly, right? When let's say, we see a product from a popular brand and we always presume, oh, we are sure the quality of this product would be good because it is coming from that particular brand. Similar in a similar fashion, okay, the book of this author, it would always be interesting to read, or maybe it is from that popular series. I see the series name, oh, definitely I'm going to have a more keen interest in this because I know what would be the genre, what would be the kind of writing that I'm expecting. So that is the purpose of a trademark, which is source, just identifying the source from which the goods or the services are coming in. As far as copyright is concerned, again, like she very crisply put it, that it is basically the protection and reward for the creative output or input of a person. So the moment creativity is involved, whether it is in a literary form, whether it is in a musical form, a dance form, a dramatization, anything, the moment the element of creativity comes in, that is when it will fall in the category of a copyright. Right? And then patents is again invention. So the moment technology or invention or advancement by way of technology comes in, which helps industries in advancing, it has industrial application. That is when the category of patents, comes in and assists in protecting those kinds of work. So intellectual property is all about the output of your brain, but that also has various categorization, whether it is an invention, whether it is creative, or whether it is a company name or a business name or a brand name. That is the difference in categorization of the various kinds of works.
Thank you so much. You guys these three terms, which is confused by everyone. And yeah, and you have also learned that exactly these two terms definition today. So moving ahead, my next question to you: that what is an author's copyright and how much does it cost to register? So I would like to start with the Shani ma'am.
Thanks, Tusa. So basically, the copyright that authors are most going to be concerned with is the literary work. So basically, what is copyright? Copyright is not one specific right. It's actually a bundle of rights. And it is given to, like I said, anybody involved in the creative process. So there can be various kinds of copyright. And for our author's sake, the one that is most important to them is that of a literary work. Now, what is a literary work? Literary work is basically anything in writing. It could be a book, it could be an article, it could be lyrics, it could be a play, it could be a script, it could be a concept note. Anything which is in writing is a literary work. Right. And again, now this is a very interesting concept in copyright. A literary work need not have literary merit, right? Because there are so many people who may have different interpretations of what is literary merit, right? So Chiclet may have literary merit for somebody, but somebody else might think that it doesn't, it's not serious work. So that's not what copyright is going into. As long as it's in writing, and it's not an idea, it has been put into execution, it has come onto paper. So literary work actually does not have to have literary merit, because literary merit is something that is very subjective. What is one person's literary merit might not have, might not be meritorious to someone else. So it is basically something which is fixed, in the sense it's not just an idea, it has been put down on paper, it has been put in the form of actually written words. So the moment that happens, there is copyright that exists in it. So for the authors, it's very important to understand that in India, it's not important, it is not essential to have a registration in copyright in order to claim copyright in it. Copyright exists in the moment the author creates their work. For example, the moment they finish writing a book and there is a book or there is an article, copyright will automatically exist in that. And registration is only a tool that is given to authors to be able to protect their work better. It is only a tool that will help them establish that they are the creators of the work, they are the originators of the work, they are the authors of the work, and the time of creation. If it comes to an issue where they have to prove whether they are the originators of the work and whether it's an original work, because originality is a very important concept in copyright. We get copyright for original work. Original in the sense that it should be originating from the author. It should belong to the author. It should be the creation of their mind. As long as you are creating an original or a new work, the moment you create it as an author, you will have copyright in it. Registration is only an additional tool that is given to authors to be able to protect their work. It is not essential to claim copyright in their work. So the moment an author writes a book or an author writes an article, copyright exists in it. And that is something that is very important for authors to understand. How can you start claiming copyright? The moment that you create the work, once you finish with the work, start putting the copyright symbol. I think everybody in the literary sphere knows what the copyright symbol looks like, with the year and the month and the date of creation on all your work, especially when you are sharing it with publishers, especially when you're going out in the market to try and sell that work. Start putting in your copyright notice to give an indication to the world that this is my copyright. I have created it on so and so date, and I have intention to protect my work as a copyright. Another point which is important to make here is that copyright does not sort of distinguish between length of a work. So you could have copyright on say lyrics, you could have copyright on a short concept note, you could have copyright on a book, you could have copyright on an anthology. So copyright exists the moment something is put on paper, and you have expressed your ideas through that. Again, copyright also exists for non-fiction work, because it doesn't have to be literary in the sense that we use the word in general parlance. It doesn't have to be it doesn't have to be having an idea beyond something, as long as you're putting skill and labor and time in creating something. So even a phone book, for example, or even a database, even a collection of maps, where you are putting things together and you are making an effort to collate those things together, and you are putting an effort to put them in a compilation form, right? As long as labor, skill and time of yours is involved in putting that together, there will be copyright in it. Surbhi, would you like to say something else?
But before,
yes, sorry.
I have one question. If someone gonna translate some book, right? Translation. When it comes to translations,
Yes.
So you talked about the originality of work. So
Yes.
if I am going to translate someone's work, so do I have to take the right from the actual authors to translate the book?
So that's a very interesting question, Jyotsna. So again, now that comes back to the original thing that I was talking about, that what is copyright? Copyright is a bundle of rights, right? So it's the right to stop others from publishing a similar work. It's the right to make translations of your work. It's the right to make adaptations of your work. It's the right to publish copies of your work. It is the right to communicate your work to the public in any form. So these bundle of rights are what you get as the right in copyright, right? So the original right to translate a work actually belongs to the author themselves. They have the first right as the author to translate that work, right? However, because I think India is such a unique country where there are so many languages, there are so many various groups of people to reach out to. What the copyright law in our country does is that 7 years, it gives 7 years to the original author of the work to translate it into whatever language or whatever form it wants to. After 7 years, if you are interested in translating that work in a language which it is not available in, then you can approach the copyright board, which used to exist. Now it doesn't. Now, now it's the courts. You will have to approach the courts and you will have to seek permission to translate that work, or the copyright office. You have to approach those and you have to seek the permission to translate that work into another language. And there will be a particular royalty which will be fixed, which you will have to pay the original author.
Okay.
But you can get a right to translate that work. And in that translation, as the translator, you may enjoy an independent copyright for that language.
Okay.
Right? So if somebody is publishing the translation, say you have translated a work in Malayalam, beyond what the original author has done, then as a translator you have a right in that translation, a copyright in that translation in Malayalam. If anybody is to publish the identical translation in Malayalam, they would have to take your permission. You become the author of the translation in Malayalam,
Okay.
right, for that limited purpose.
So whatever profits they're gonna earn from the translated book or whatever paper, so there is some kind of percentage that the original person needs to be.
The original author will have to be paid some sort of royalty.
Okay.
So yes, you can always directly approach the author themselves. That is a route that is always available to you even before the expiry of the 7-year period, because copyright again is something that can be controlled by contract. Right. So as long as you are entering into a contractual relation with the original author, they can assign you or they can license you the right to make that translation.
Okay.
However, in the event that the original author is, for example, no more or not available or not traceable, or they are not willing to give you the right, you always have the option of going to the copyright office or going to the courts after an expiry of 7 years of the publication of the work, and get a right to make the translation in a language that you want.
Thank you, Shani ma'am. Over to you, Surbi ma'am. What's your take on this?
All right. So I'm just going to go back to the start and, starting with the question of what is copyright. So, of course, apart from what, has already been discussed, I think it's important to understand, for authors to understand that the whole reason behind, introduction of the copyright right is to incentivize the authors. Now, how is that incentive granted by way of giving copyright? All the rights which are the bundle of the rights which are given as copyright are exclusive rights. And the reason for exclusivity is that because each of those rights forms a separate revenue stream. The whole purpose of copyright is to give economic benefits and economic advantages to the authors and the artists, so that whatever works that they are ultimately publishing, they can be commercialized and they can generate revenue out of this. So, for example, what we were just discussing, the rights of translation. Now, if the author wants, he can actually negotiate contracts where each translation is a separate revenue stream, right? Like, for example, of course, let's say the original work is written in English. So Hindi is a separate revenue stream, Malayalam is a separate revenue stream, Punjabi is a separate revenue stream, Gujarati is a separate revenue stream. A ebook, a digital book is a separate revenue stream. The hard copy of a book is a separate revenue stream. Similarly, when it comes to adaptation, if a book has to be adapted as a play or as a movie or as a mini series or web series, each of those is a separate revenue stream. And this, like Ishani ma'am discussed, can be controlled by way of a contract. That is the whole purpose and benefit of why it is important for authors to understand copyright, because ultimately when you are putting in work, it's your asset. For every author, they are putting their time, energy, their brain, they are dedicating their significant efforts in making that work. So ultimately it needs to be, if it's an asset, it needs to be protected and then it needs to be rewarded. That is the whole intention of copyright. The way those bundles have been created, each of that bundle is such that you can use it to monetize your asset. Apart from what has already been discussed, this is an important aspect.
Thank you, Surbhi ma'am. Okay, so moving ahead, my next question: what challenges do authors face if they do not acquire a copyright? So I would like to start with Ashani ma'am.
Right. So basically, if you don't register a copyright, I think that is the language that we should focus on here. So if you don't register a copyright, because like I already pointed out that copyright exists in the author from the moment they create the work. So actually they have copyright even if they don't know they have copyright in their work, right? So the registration process, the challenges, they can face if they don't register their work. I think first of all, when you are negotiating with publishers or when you are, even putting your work out to the public in order to get it published, right? There is often the fear in an author's heart that it can get, stolen, or the publishing company may publish it without actually acquiring the rights from it, or it may get leaked. The work may get leaked on the internet, or on it may become available to the public in some other form. So one way of preventing that is definitely getting a registration of copyright, because your rights as an author become stronger by it. So when you are already, sort of in the process of seeking a publisher, if you already have a registration of place, or even if you have an application in place, you are more assured that you have a better right in that work, and therefore you will deal with the people and the publishers accordingly. You will come in stronger for having that registration right? So definitely it helps in the negotiation process. It helps in giving you a solution if something, God forbid, something wrong happens to the work. Like I said, if it is, leaked, or if, somebody is trying to release it out into the public without your consent, then you have a stronger right to be able to protect it, because you don't have to prove your authorship and you don't have to prove creation, right? Because simply by virtue of having that certificate in your hand, your ownership of that work or your authorship of that work and the date of creation of that work is proved. So one, it helps you negotiate better when it comes to selling your work, when it comes to publishing your work. Secondly, if something is to happen by which your work gets leaked, it gives you a stronger tool to go after people. Thirdly, if the question of sometimes it happens that there are two very similar works, right? And then the question comes that who is the actual owner of copyright in that work? Who is the person who created it first? Having a registration certificate definitely helps date your work, right? Because there is a date for that copyright registration. You always know that you created it on certain date, and it's easier for you to for you to prove that you created it on that date. You don't have to go into separate proof. That certificate is enough proof to show to the world that the work was created on a certain date. So definitely what a copyright registration certificate does is it empowers an author to have stronger rights in their work and to deal with that work in a better manner. So according to me, that is the most important aspect of a copyright registration. Even without a copyright registration, you have strong rights. I'm not saying that you essentially need it, but I would just say that the task on the author becomes slightly more, more difficult in the sense that you have to maintain exact records of when you created the work, how you created the work. So often you will hear lawyers say, like, when you finish your manuscript, mail it to yourself, because it will at least date the work. You will know that it was created on such and such date. Or now with computer technology and all, date all your work, right? You can always show when the Word document was created. But again, because writing is not a one-off process, it's a period of long time. You yourself date your documentation when the book is finished or when the article is finished. So the task of proving the creation and that you created it becomes slightly more difficult for an author without a copyright registration, but it can still be done. Like, if you don't have a registration, it does not mean that the author is without rights. They can definitely prove their rights, but they will have to prove that they were the first ones to create it, that it is an original work that is coming from them. And definitely, again, contracts come into the picture here. So when you are sort of sharing it with the publisher, it's always important to have a non-disclosure agreement in place, a non-compete agreement in place. These kinds of documents or these kind of agreements actually prevent leakage of your work out into the public, or people dealing with it without actually giving you credit. And I know sometimes when you're a new author, or you are just coming out, it's not possible to negotiate with big publishing houses, because the structure of power is actually completely against you. They are the powerful people and you're just a newbie, right? So in those cases, even when you are sort of dealing on email with somebody, it's very important to record everything, right? Even when you are dealing with somebody, just just put it down on an email. It doesn't even have to be an agreement in the sense where they sign something. You say that this is being shared with you in confidence. This is my copyrighted work. I have copyright in it. Please do not disclose it with a third party, disclose it to a third party without my permission. Just have those standard statements in the email for, your own protection, whether it's in your signature, whether it's in the body or content of your email. It's very important to put it out there that this work is something that you are treating with confidence, and you are treating with respect, and you're treating it as your work, and therefore there is obligation on the other side to actually treat it like that as well. So that is what I would like to say on this point.
So, in addition to what Ishani ma'am said, I feel like awareness is a big deterrent, right? If you're sharing your work with a copyright notice, with a disclaimer, the person who receives it also, becomes aware of the fact that, okay, the person who shared this email, he's aware of the rights. He's aware that copyright grants him or her, certain rights as the author of the work. If you just share your work, without any notice, without anything, it basically gives the impression that you are unaware. If you actually go through the process of getting your copyright application filed, any lawyer with whom you are working on this will advise you on exactly what your rights are. Once you're going through the process, you would understand what are the rights that you actually have, and what are the various steps that you can take to ensure that the person with whom you are communicating, whether it is publishers, whether it is distributors, they take cognizance of the fact that they are dealing with an aware person. it is the responsibility ultimately of the authors to ensure that they know. It is, I mean, I do understand that at times you're just in a position where, despite knowing you cannot take certain actions, we completely understand that. And that's where negotiations and contracts come in. But the first step is to be aware of what your rights are. And to do that, the process of just applying for that copyright registration, filling up that form with various particulars, understanding what are the rights of the authors, why is it so important. So, slightly detracting from the main topic, but whenever you are filing a copyright application, including for a literary work, the one thing that you need to have, which is mandatory, is a no objection certificate from the author. Because the Copyright Act recognizes the importance of an author. Because rights can be assigned, right? Someone else can become the owner of the work. But copyright specifically protects the author, even if that work is ultimately being assigned to someone else. So that NOC from the author is one of the most important documents. Now, you would not get to know that unless you actually go through the process of filing a copyright application. So for me, I feel awareness is a huge deterrent. Now, that awareness has to be two-way. One, you need to be aware of your rights, and then you need to make sure that the other person also knows that you're aware of your rights. So they also feel that, okay, we can't take this person for a ride. We can't, just blindly copy. And the way of doing it is, like Ishani ma'am said, NDAs, putting copyright notices on the work itself. Ultimately, today technology helps us have watermarks even on digital copies. So just doing these simple things, putting the copyright disclaimer, specifically making, those statements that this work belongs to XYZ, that is an indication that you are well aware and, you will fight to protect your work.
Thank you so much. Like in your profile that you guys mentioned that you guys worked both in India as well internationally. But my next question is specifically for Indians and for the India. So what is the ownership and the authorship of copyright in India? When we talk about India, so what is the exactly authorship of copyright here in India? So yeah, start with Ishani ma'am.
Right. So basically, authorship of copyright and ownership of copyright are two separate things. Like I think during the course of our conversation also that has already been established. So the actual author of a work is always the first owner of copyright, unless there are certain exceptions which I'll come to later. But if you are creating the work, then you are the author of that work, right? And you are also the owner of the work till you part ownership with that work, right? So as the author, I have created a work, I become the author of that work and I become the owner of the work. Now, when I approach somebody to publish this work, they will also ask certain things from me, right? So I might have to part with the ownership of my work to the publisher, for example, so that they become the owners of the work, but I will always remain the author of the work, right? So that is the difference between authorship and ownership. Authorship is the person who's actually creating the work, and ownership is the right of is the person who will exploit that work and earn revenue from that work. So you as a there now self publication is such a big thing in the publishing industry right now. So as a self publication as a person who's self published, you may continue to be an author and an owner of the work. However, in most cases, what happens is that the publisher will ask for ownership of the work, right? So they become the owners of the work and you continue to be the author of the work. Now, again, it is not necessary to part ownership to them. There is two concepts. There's assignment and there's license. They could technically even publish the work on a license, right? But the way the industry functions, it is mostly an assignment that is taken, right? So then they become the owner of the work. And again, this is a power play concept. Whoever has the more power gets in negotiation gets to keep the bigger share of the pie, right? But apart from ownership and authorship as concepts which can be like I said, which can be contractually modified, there are certain rights which an author inherently has under the law in India, which cannot be assigned away. So you have the right of being called the author of the work, which is the right of paternity. That is the way it is called, to be acknowledged as the author of the work. The law says that you cannot assign away your right to be acknowledged as the author of the work. So tomorrow, even if the publishing house acquires the ownership of the work, they cannot publish it in the name of someone else. They have the right, you have the right to challenge that in a court of law and claim paternity or authorship of that work. And second is the right of integrity. The integrity means you have a right to prevent your work from being mutilated or your work from being destroyed. So if, the publisher eventually publishes a work which according to you is destroying the original work or is mutilating your original work, you again have, even if you have assigned away your rights, you have a right to prevent that from happening. Right? So the right of paternity and the right of integrity are two rights which remain with the author, even if you have assigned away your rights to anyone else. Secondly, recent amendments in the Copyright Act also say that if your work, even as an author, is to be included in a cinematograph film, in a movie, you cannot assign away your right to earn royalty. As an author, you will continue to enjoy a royalty in that work if it becomes a part of the cinematograph film. They cannot ask you to assign away the right of royalty that you have in that. Right? And this is something that is very important for authors to know, because often this is what was happening earlier. That even though you were entitled to royalty in something, the contract would say that I assign away my right to earn royalty in this. Right? And I'm taking a lump sum payment. But law does not permit them to do so anymore. As an author, you cannot ever assign away your right. Right? So this is another important concept to understand in ownership and authorship. Again, in the publishing industry, especially, there is a unique concept of pseudonymous works or basically works which are anonymous. Right? Now, this is a very important concept. So what happens when you have anonymous works or pseudonymous works, right? So if you are a writer who has published an anonymous work, then the copyright in that exists, because again, like the term of copyright, how do you calculate that? We have not had that conversation as yet, but basically the term of copyright is the lifetime of the author plus 60 years. So as long as the author is alive plus another 60 years is the lifetime of copyright in a work. But in the case of a pseudonymous work or in a case of a, work where anonymous, yes, in the case of an anonymous work, it will be 60 years from the date of publication, because we don't know who the author is. So the copyright in that work will exist from the year of publication of the work. 60 years from the date of publication. Similarly, in a pseudonymous work, where it's not an actual person that exists, the term of copyright would be 60 years from the year of the publication of it. But maybe if in this lifetime of 60 years, somehow the pseudonym is revealed and a real author comes out, like J.K. Rowling, right? We all know that that's not a real person. That was her pseudonym. The moment people start recognizing the, actual person behind the pseudonyms, the copyright again, the term of copyright will again change to lifetime of the author plus 60 years. So from the time of, that person coming to be known as the author of the work. So that was some of the things that I wanted to talk about. Joseph, do you want to ask anything or should we move to Surbi now?
Yeah, we can move to Surbi because we don't have much time.
All right. So, the first thing that I would want to discuss in the difference between authors and owners is that whatever we have discussed so far, which is, the bundle of exclusive rights, now those rights specifically belong to the owners. Author is the person who's creating the work, and as a general rule of thumb, the person who is creating the work is also the owner. So author is the owner. That's the general rule. But the same can be varied by way of contract. Now, generally, what happens is when you are writing for a person, or you're already engaged by a publishing house and you are writing as per their theme, what happens is you sign a one-page contract. That one-page contract can just contain 2 or 3 words, such as a commission work or a work for hire. Because it's a single page contract, you would not pay much heed to it, and you would sign it without thinking of the what is the legal meaning of those terms. But just using those 2 or 3 words, an author can be parted away from the ownership. So it's very, very important that whenever you're signing a legal document, because copyright is given to the owner, an author only has limited rights, which Ishani ma'am already talked about, is the right of paternity and right of integrity. Because if the idea or the transaction is such where you intend to retain more of the rights, you want to have commercial benefits, you want to monetize the work, then you need to be the owner. And if you need to be the owner, you need to be very cautious of what is the piece of paper or a couple of words that you're signing, because that can completely impact the rights that you have in a work. We have discussed all the extensive rights, the bundle of rights which copyright is, versus those 2 or 3 rights which are the rights of an author. So to understand this difference is very, very important, because the moment someone is able to demonstrate that you have developed the work for them as per their brief, as per their instructions, under their supervision and control, they are the ones who have been guiding you through the entire process. They will be able to demonstrate that actually the first owner is them, the work belonged to them. And while a person can become owner by way of assignment, so let's say I am the author. As a rule, I have created the work on my own, I am the owner. But the moment I enter into an assignment agreement, I am giving away my ownership. When I give away my ownership, that means I'm acknowledging or I'm aware of the fact that I'm giving away, all the copyrights. But if I'm doing it just because I've been engaged by a person, or I've signed a contract with a publishing house, I may not be aware. I'm not aware of the fact that I'm already signing away all of my rights, even before the work is created. So this is very important. In copyright, you can actually assign away a work even before the work is created. And the moment the work comes into existence, the publishing house or the person who's engaging you, they will become the owners. So this is why contracts become extremely important, specifically when you are talking about authorship versus ownership. Because the law provides you a general rule that as the author, you will be the owner. But it also says that contract can change it. So the moment you're signing any piece of paper, it is very, very important, to understand what is the implication of that piece of paper, whether it is one para, one line, or 500 pages. Each can impact your rights in different ways. So that you need to be very aware of. Then I think another thing for us to understand is, while we've already talked about originality, but it is important to understand that copyright, when we say copyright, what it is protecting is the expression, the way we are capturing a work. So you cannot protect just general ideas and themes by way of copyright. To give you the most basic examples, there are, I think, more than 3 books and more than 3 movies on just the life of Bhagat Singh. It's a historical event, right? It's a thing that has happened. Or let's say the fight on Indian independence. Now, these are themes. You can definitely protect the way a book is written, the way the story has been captured, the sequence of events, the form and manner of writing. And that is the expression. So, what copyright protects is the expression. But if it is a general idea, that cannot be protected. If it's a historical event, you can protect the way you are reciting that historical event. But you cannot claim, rights to say that, okay, because I am the first person to be writing on this, no one else tomorrow can turn and, write on this or make a movie or make a series. No, you cannot do that. Even if you come up with a completely, let's say, for example, Harry Potter, right? That is a completely different way, a magical world, where it's a school where students are going, things are happening. Now, even J.K. Rowling cannot protect the idea of, writing about, let's say, a magic school. Of course, the names, the way she has written a separate world where magic is real, all of this she cannot protect. The way she has written the characters that she's written, the entire storyline, That is what is protected, but not the idea, not the theme, not, just the general concept. So that is again something that one needs to be aware of, because there is a limitation to rights. As an owner and as an author, you definitely have rights, but you have the rights in exactly what you have made, the way you have captured it, the way you have expressed it.
Thank you, Surbhi ma'am. You just mentioned a little bit about limitation as well, because it was my next question. But yeah, thank you so much for joining us today. And I had just a very insightful conversation with you. And I'm hoping that the audience would also enjoy it as much as I did today. So thank you so much. And I'm hoping that this session will gonna add value this to the literature festival, and author will gonna learn from it so much. So thank you.
Absolutely. That's a hope too, Jyotsna.
Yeah.
Thank
Thank
you.
you so much, guys. Have a
And
good
I
day.
think we also missed that question, when you asked about what is the cost of registering a
Right,
copyright
right.
in India. I think that little part was left out. So, just wanted to briefly say that, there is a government fee aspect of it. The Copyright Office charges something which is very minimal for literary works. It's 500 rupees per literary work. And the lawyer's fee in most cases will vary, probably ranging starting from 5,000, and it can go to any amount of fee, but on average 5,000 to 7,500 is something that a lawyer will charge. So it's not actually something very high, that often authors feel that this is the legal fees will be crippling for them. It's not like that. It's a very reasonable fee. And as Sagar Chandra and Associates, we also provide a lot of discounts for fresh authors and newbies. So I just want to say that don't be afraid of reaching out to lawyers. Often, that initial investment in your work will really help you in the future to prevent any issues cropping up. That's all. Thanks so much for today's session, Jyotsna, and I hope
Thank
it
you
was.
so much. Thank you. Have a good day. Bye.
And
Bye.
I
Bye.
really wish that this is just the beginning of the conversations, and authors just take cue from this and feel free to research more, read up more on their rights, are more aware, so that as a community they become stronger.
And yes, Frontless Media team and PVLF team is privileged to have both of you today. And
Thank you.
yeah, for discussing on the copyright. Thank you.
Thank
Bye.
you so much. Thanks. Bye bye.